because the Chief Minister said, I am ready to hold that test. And para 3 was there on that day of the 10th schedule. And what did the governor do? 356. It's in that context that Bomai says, which is why I said the other day, these decisions are contextual. There is no general principle that can be applied across the board. There can't be. Freedom of speech is a general principle. How you will actually recognize it is the context. So, in this connection, it is necessary, I'm quoting I'm sorry. In this connection, it is necessary to stress that in all cases where the support of the ministry is claimed to have been withdrawn by some legislature, the proper course for testing the strength of the ministry is holding the test on the floor of the House. That alone is the constitutionally ordained forum for seeking openly and objectively the claims and counterclaims in that behalf. The assessment of the strength of the ministry is not a matter of private opinion of any individual, be he the governor or the president. It is capable of being demonstrated and ascertained publicly in the House. So first you must reach a bona fide, constitutionally valid conclusion that this requires a floor test and on relevant considerations. If you are able to justify that to the court, then the only remedy is the floor test. Well, it's the next paragraph. I just read the highlighted portion, para 391 at the bottom. Whether the Council of Ministers has lost the confidence of the House is not a matter to be determined by the governor or for that matter anywhere else except the floor of the House, correct? Principle of democracy underlying our Constitution necessarily means that any such question should be decided on the floor of the House. The House is the place where the democracy is in action. It is not for the governor to determine the said question on his own or his own verification, which is what exactly he did by recognizing a faction. Now let's kindly come to para 32. Thus, S.R. Bomai is not an authority for the proposition that the governor must order a floor test whenever a claim is made that the elected government has lost the confidence of the House, irrespective of whether such claim is based on unconstitutional or extraneous considerations. Rather, S.R. Bomai, it was categorically held that the power under 356 cannot be used to. Rather, in S.R. Bomai, it was categorically held that the power in 356 cannot be used to sort out internal differences in or intra-party problems of the ruling party. Para 82. If your lordships will just allow me to show that, if it's convenient. Well, I'll show that here. Volume 2.
That is Bomai?
Judgment.
Yes.
Judgment.
We'll read Bomai here. You have extracted it.
Yeah, I've extracted it.
Yeah, we'll read it from your extract. Much easier. We've got Bomai, of course.
Yes, I purposely did it, Mala, so that otherwise you'll have
we don't have to go back and forth at all.
You have extracted it also.
Yes, I've extracted it. It's okay. Well, it's actually, I must give credit to my colleagues.
Yes.
Well, it's Mr. Tiwari, Mr. Devdutt, how wonderfully they have prepared this case. It's extraordinary. And I owe gratitude, sense of gratitude to them. Sort out internal differences or inter-party problems of the ruling party, and that exercise of this power for a purpose extraneous or irrelevant to the one for which it has been conferred by the Constitution would be vitiated by legal malafides. You are now looking at an intra-party dispute. They have come to you, they are 34, I recognize you, I recognize the leader because he is the leader. So the governor is recognized. I'm sorry. And this intra-party quotation is from Sarkari Amalats. It is adopted by Bomai. And it is consistent with those propositions, Malats, that I read to your lordships of Sarkari Amalats adopted by Rameshwar Prasad. See, you can't enter into an moment you say, okay, I'll recognize these three people, I will entertain these two people, and then now you have lost majority, now you have a floor test. Impermissible. That's the old non-10th schedule regime, the Ayagram, Gayaram regime. Then, crucially, para 34, S.R. Bomai, Justice Jeevan Reddy further observed in the context of the 10th schedule that we're equally of the opinion that the High Court was in error in holding that the enactment of a 10th schedule of the Constitution has not made any difference. The very object of the 10th schedule is to prevent and discourage foreclosing and defections, which at the time had assumed alarming proportions. whatever may be his personal predilections, a legislator elected on the ticket of a party is bound to support that party in case of a division or vote of confidence in the House unless he is prepared to forego his membership of the House. The 10th schedule was designed precisely to counteract horse trading. Except in the case of a split, a legislature has to report his party willy-nilly.
So, Sibal, the only problem is, I just looking at it from this point of view, the basic principle of parliamentary democracy is that a government has to be accountable to and must have the faith of the House. Now, suppose a group of, say, the government has X number of legislators, and take a hypothetical case where X divided by 2, say that we have no faith in this government, though we were elected on their ticket.
Correct.
They say that, look, okay, we incur the disqualification, but we don't have faith in this government. Now, going by your logic, the governor can never call a trust vote because he will say, look, you have been elected as members of the House. You can't say that you have lost faith in which case, even though the government now really effectively has only X by 2 of its confidence in the House, the strength in the House, still the government must continue, the government has to continue. It's basically reduced to a complete minority probably.
Your Lordship is absolutely right. May I answer that, Malaj? The session is on. Finance bill has to be passed. Vote against it. Government will fall. What's the problem? This is not an insurmountable legal issue, Malaj. Any vote against it. But what they want is, they want to topple the government, become the chief minister, then tell your lordships, now the speaker will decide. This is not constitutionally permissible. Your lordship is absolutely right. What time does the government lose majority, lose confidence of the House, Malaj? At the time when it is reduced to a minority. At what time does it reduce to a minority? When they vote against the government. It is reduced. That's the solution. Till the time they vote against and the government becomes a minority, it's accountable to the people. The governor cannot assume that they have lost majority, therefore there is no accountability. That's not permissible as far as the governor is concerned. That's respectfully the responsibility to the query that your lordship raised. Prime Minister Nasim Rao ran the minority government. It's not as if governments can't be run by minorities. Point is, they don't want to lose the membership of the House. It's a double whammy, Millers. You lose the membership, you don't become a minister. You have to fight an election. You may win, you may not win. Here, you topple the government to become a minister, you become a chief minister. Use the governor's office for that. Your Lordship, Millers, I don't have to say anything more. My political experience and your judicial experience, Millers. We have reduced ourselves to that we are mocked. People don't believe us anymore. Anyway, so
now we go on to Shivraj Singh.
Then Shivraj. Respondents relied on the law in Shivraj to contend that where the governor has reason to believe that the incumbent government does not possess the support of the majority, the correct course of action would be for the governor to call upon the chief minister to face the assembly and to establish the majority of the incumbent government within the shortest possible time, irrespective of the fact of disqualification. Well, I'll just read the highlighted portion.
Distinguished clearly.
Undoubtedly, the purpose of entrusting such a function to the governor is not to destabilize an existing government. Well, as I read the beginning, as a matter of constitutional law, it would not be correct to proceed on the basis that the constitutional authority entrusted to the governor to require the council of ministers to prove their majority on the floor of the house can only be exercised on the very inception after general elections are held, and not when the governor has objective reasons to believe that the incumbent government does not command the confidence of the house. The governor is not denuded of the power to order a floor test, where on the basis of the material available to the governor, it becomes evident that the issue as to whether the government commands confidence of the House requires to be assessed on the basis of a floor test. undoubtedly the purpose of entrusting such a function to the governor is not to destabilize an existing government. When the satisfaction on the basis of which the governor has ordered a floor test is called into question, the decision of the governor is not immune from judicial review. The court would be justified in scrutinizing whether the governor prima facie had relevant and germane material to order a floor test to be conducted. So we are not against the floor test, we're against the considerations on the basis of which the floor test was ordered. It is respectfully submitted that Shivraj Chauhan, there are no disqualification petitions. Now, this is the other thing, pending against the MLAs whose resignation was under consideration. As noted by the Honorable Court in para 41, notices of disqualification had been issued against 6 MLAs on 13/3, but the Speaker had accepted the resignation of these 6 MLAs on 14/3, which I mentioned to your Lordships yesterday. As regards the other 16 who had tendered their resignations, the Speaker had not yet accepted their resignations. When the Governor directed a floor test to be held, the disqualification petitions were not pending against MLAs whose resignations were under consideration when the floor test was held. On the other hand, in the present case, Governor's decision to direct a floor test to be held on 20, knowing full well that the very MLAs of Shiv Sena Legislative Party who the governor had recognized are facing disqualification. Furthermore, this Honorable Court's observation in para 80, the pendency of proceedings before the Speaker cannot be a valid basis to not have the confidence of the House in the government determined by the convening of a floor test, are premised on the constitutional principle that neither the court nor the governor has any right to impinge on the Speaker's power to decide on the issue of disqualification. This court cannot say that you cannot decide or I give 10 more days or 10, 15 days. That's not the power. That's not the function of the court. It is straight law that neither the governor nor for that matter this court has the power to impinge upon the authority of the Speaker to take a decision on the above issues. Well, now 5 judges have said that. Therefore, that order on the 27th put us in a situation, where the elected government was toppled.